Welcome to HH Law. I am John Henderson. Today we are talking about the Second Amendment and in particular two cases that dictate and help us understand what the Second Amendment means. All right, as I said, we're talking about the Second Amendment today. Let me read it first so that we're all on the same page about the Second Amendment. And then we're going to talk about two particular cases and some takeaways that everyone should know about the Second Amendment. Let's read it. So the Second Amendment was ratified December 15th, 1791. And it says this: a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And so there's a whole history behind it. We take a lot of guidance, obviously, from the British, which is some of the foundational information that we take into our legal system, but then also from the American Revolution and what was going on around that time to help create a lot of the laws and a lot of the things that we have today. And in particular, let's take a look at the District of Columbia versus Heller, which is a 2008 case. The opinion was written by Supreme Court Justice who has passed. His name is Justice Scalia, and he was a big brain scholar and a wonderful author of many good opinions. And one of his big opinions was this Heller case, as it's become known. And so when the Supreme Court hears a case, they issue opinions and basically outline what their interpretation is of an existing law. And so they look at the Second Amendment and they say, hey, is this law that has been created by a state, and in this instance, it's the District of Columbia, is this law that they have instituted, is that constitutional or not? And so that's the question that is presented in front of them. And in this instance, there was a police officer who filed an action because his application to obtain a handgun was denied. And so the police officer argued that his application should not have been denied and in fact violated his Second Amendment right to bear arms. The fact that the District of Columbia, that Washington, D.C. denied that. And so the court heard the case and arguments. And Justice Scalia wrote a great opinion, which we are going to link in the text below so that anybody can read it, because it's a great explanation and way of understanding the way that the Supreme Court thinks about things and analyzes particular legal issues. And he does a good job taking complex issues and making them understandable for all of us. But he hinges his opinion on a few things. Number one, and I'll talk about these a little bit more specifically, the normal sort of ordinary meaning of what the text says. The second is the historical background of the right to bear arms, that Second Amendment language. And then the third is something called natural law or natural rights. And so let's take those one by one. So the normal and ordinary text of the Second Amendment, he says, suggests that the amendment's operative clause, the portion that says the right of the people to keep and bear arms shall not be infringed, he says that this seems to be, on its face, a guarantee of individual rights to possess and carry firearms and weapons in case they are confronted. And this is not just in case you're confronted by another individual who wishes you ill. It's also a confrontation with the state, the federal government, any sort of government that might try to infringe on all of your sort of natural rights, as he calls them. And so what he says is that the Second Amendment guarantees the individual right to possess and carry weapons in case of confrontation, and that does not depend on service in a militia. And this is a point that he makes in this conversation, which is, yes, it says that there's a militia, and then we have a right to bear arms, but those are two separate things. And so he is just pointing out that if you think back to the historical context of this, is that the militia was before the United States Army existed. And so this is how he's referring to this, is what the Constitution says when the amendment was ratified. But it was not contemplating the sort of military that we have today, but he's pointing out that it is necessary for the federal government and state governments to have militia, some sort of military service. Therefore, it is necessary for individuals to be armed to defend themselves against the sort of oppressiveness that a government who is armed could impose on citizens. And so then let's take a look at the second big point that he makes is the historical background of the Second Amendment. And he says, and this is a quote, that it has always been widely understood that the Second Amendment codified a pre-existing right. And so that right was understood from the British Parliament, passed on, and we adopted it here when we created our Constitution as well. He further says that it's not intended to lay down a novel principle, but rather to codify a right inherited from our English ancestors. So this isn't a new concept that the Constitution created, but it's an old concept. And, lastly, he says that in the 1600s, the English history and early American colonial views suggested, and I'm quoting again, that there's no doubt that the Second Amendment conferred an individual right to keep and bear arms. That was the plain text understanding. That is the historical understanding of the Second Amendment. Let me quote a couple other places here. He says that the Second Amendment is the very product of an interest balancing by the people, and that it surely elevates above all the other interests the right of law-abiding, responsible citizens to use arms for self-defense. And again, that is self-defense not only from government encroaching on our rights, but also from other individuals encroaching on our rights. And so that is the general background here. The third element that you'll see in the opinion, so you have the plain language of the Second Amendment, and then we have the historical background, which supports the plain language, but then also the concept of natural law and natural rights. That is, that our rights existed before the country. It existed in Scalia's view from God, created humans with certain rights. We see this in the Declaration of Independence, unalienable rights. Created those rights, and the function of the Constitution is to prevent the government from encroaching on those rights. And so this idea of natural law, you'll see weaved into this opinion over and over again, natural rights, that we have a natural right to self-defense. Okay, so let me round out the Heller decision by quoting this, and I think it's very apropos here, is that he says, Scalia writes, just as the First Amendment protects modern forms of communications, and the Fourth Amendment applies to modern forms of search, the Second Amendment extends to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. And so there he is addressing one of the criticisms, which is, hey, the Second Amendment was created when there were just muskets and it was slow loading action. And now we have the semi-automatic weapons and other handguns and things that are much more dangerous. And that is an argument against the Second Amendment. But he's addressing it here is that, well, we continue to extend the First Amendment. We are continuing to extend the Fourth Amendment, other amendments to the Constitution, elements of the Constitution as well. The Second Amendment continues on to this day because the principle holds true that we are all entitled to protect ourselves from other individuals and to protect ourselves from government infringing on our rights. Moving forward to 2022, that opinion by Scalia was 2008. We move forward to 2022, and there was a case, New York State Rifle and Pistol Association versus Bruen. And this opinion was written by Justice Thomas, and basically he upholds the exact same thing. It seems to me, and I'm no constitutional scholar, I'm just telling you from a basic lawyer standpoint what some of these cases mean and what the Second Amendment means. But from my vantage point, it looks like this was a challenge just to test the court again to see if there's any movement in the Second Amendment. But in this case, the state of New York did something peculiar, and they required applicants to demonstrate a need for self-defense to obtain a license to carry a handgun. On its face, most people, I think, assumed that the Supreme Court would strike this down, which is essentially what they did. And Justice Thomas writes an opinion upholding Heller and also reinforcing the Second Amendment. The reasoning is that the plain text, again, confers an individual's conduct to protect themselves. The holding in the case rejects the state of New York's law that they created saying, hey, you have to prove that this is a self-defense move. It says, no, that's nonsense. You have a ancient, historic plain language, meaning interpretation of the Second Amendment behind us that says that the state of New York cannot create a law that would force people to have to justify why they would need a firearm. So he says that a state could not prevent a law-abiding citizen from publicly carrying handguns because they had not demonstrated a special need for self-defense. And so essentially you strike that down. So on the totality, it is very clear, and we're going to link both of those cases and opinions just so that you can see for yourself what the Second Amendment means. Unlike other areas of law, this one is pretty fun and entertaining to read, and both of those opinions are easy for anyone with a law degree, without a law degree, any average citizen to be able to read and understand the reasoning and rationale behind the Second Amendment and why the Supreme Court continues to rule that the government cannot infringe on that Second Amendment right. This applies across the land. This is not a state-specific thing, but we are in the state of South Carolina, in Charleston, South Carolina. If you ever have any legal questions or needs, please contact us. I'm John Henderson, and this is HH Law.